Good morning, sir.
I'd like 13 minutes on direct and to save 2 for rebuttal, please.
2 minutes for rebuttal.
Yes, sir. Your Honors, good morning. My name is Robert Burns. I'm a member of the Nashville Bar of the law firm of Howland Fisher. I represent the city of Columbia in this case. I want to start off by saying that sometimes when I've presented appellate arguments, I like to make or come up with some type of what I at least think is a clever hook line to get your attention, but I don't have a hook line today. I've had difficulty trying to come up with a hook line. The reason for that is because every time I have thought about this case and then started to substantively work on it and analyze it, I've thought to myself that maybe I'm missing something, because the arguments about the petitioner's alleged right to have a hearing here after his termination have continued and continued and continued. But every time I come to the conclusion that I'm not missing anything, that this case was filed, and respectfully, I don't think it was filed with that much merit. This case, factually at least, is based on 2 ideas. One, whether or not Mr. Cobb, who's the former fire chief for the city of Columbia, whether he qualified or could be called and described a department head within the city. Respectfully, I think that it would turn logic and common sense on its head to come to any conclusion but that he was a department head. The record that you have before you, the trial transcript from the hearing that we had back in June of 2024, is replete with comments and admissions from him acknowledging that he was essentially, I guess, what Harry Truman classified as the person that the buck stops with him. He was the department head. There are
Counsel,
8,
would
9,
you
10 different...
agree that in a conflict, a charter is going to control, sort of a local constitution, right? That if there's a conflict between the charter and ordinance or some other governmental action, that the charter is going to control under Tennessee law?
I don't necessarily disagree with that, Your Honor, and the charter provision that is at issue here with respect to the decision to deny him the hearing that he requested is section 7.10 of the city charter, and the operative language there is that all full-time employees of the city, other than the city manager, the assistant city manager, and all department heads are declared to be civil service employees.
You wouldn't disagree, though, that the charter provision does clearly indicate an express right for the fire chief, essentially, to have a hearing, and civil service hearing?
No, I would disagree with that.
Under the charter's language?
Yes, it says, section 7.1 says that department head, other than the city manager, the assistant city manager, and all department heads are not declared to be civil service employees. So hence, that was the basis on which he got exempted out. There's no question that he was the department head, and I don't know how much they're going to try to argue back against that.
What about provision 601 of the charter? All departments, offices, and agencies under the direction and supervision of the city manager shall be appointed by and subject to the direction and supervision of the city manager. The city manager may appoint one person as the head of 2 or more departments, or he may serve in that capacity. And that's mandatory sounding language in terms of important appointment with shall. So the option seems to be appoint one person as the head or serving in that capacity. So if the city manager has not appointed somebody to be the head of public safety, isn't the city manager essentially the head of public safety?
No, I disagree with that. The issue, to kind of jump forward to the issue of the Department of Public Safety, look, there's no question that there is a Department of Public Safety that was created, not created, at least passed by vote of the City Council back in 1968. But that department was never created, it was never authorized, it was never funded, it was never put into operation because there was not the appropriate ordinance that was then put into place to create that department. It's undisputed in this case that there was not a public safety director at any point in time, and most importantly, at the point when the termination decision was made, and then when Mr. Cobb requested his hearing because he claims that he was a civil service employee and civil service protected. And I think what this really goes to is the standard by which this case needs to be looked at. It's a writ of mandamus. The decision, or the standard, is whether it was arbitrary and capricious. And there was some basis for Mr. Massey, with the advice of the then city attorney, to make the decision to deny him a right, or not a right, but to deny his request to have this civil service hearing before the review board.
How is this a discretionary decision? I mean, I see your argument in terms of legally why you're correct, and I see opposing counsels why they're correct. How is this a discretionary decision that we're looking at here? And it looks like it's a legal question rather than a pure legal question rather than a discretionary decision. What's the discretion here?
Well, I think the discretion here is whether or not, well, first of all, Mr. Cobb, who was he and what capacity did he work for the city of Columbia?
Isn't that a binary, though? It's either he is or he is not, rather than he may be based upon certain criteria and consideration. And isn't that just a simple, it's a yes or no, maybe not a simple yes or no, but a yes or no rather than...
The city's position, Your Honor, is he was a department head, and there's language in the charter that says if you're a department head, you are not civil service protected. And it was on that basis that the decision was made that he does not get what it is that he is continuing to try to request here. And the end run, if you will, with all due respect, is the argument that they tried to come up with, that there is this imaginary public safety director that somehow usurped, if you will, what authority or what decision-making capacity he had as the head of the fire department, the chief, and somehow supplanted or replaced his role and his authority and essentially his standing and status as a department head. Everything in this record suggests, and I would say on an uncontradicted basis, that he functioned and operated as a department head. He showed up at department head meetings at the request of the city manager. He signed all these documents, employee and personnel decisions. That's all in the record. It was embedded into our brief, describing himself as a department head. And it was on that basis, the basis of 7.1, that clearly states that department heads, the city manager, and the assistant city manager do not get and are not entitled to the civil service protection.
I'm interested in the city code. And if you're looking at Chapter 3, the civil service system, there's a reference to employees that will be governed by, will be considered a civil service position, and it references Article 6, Section 19 of the Charter as amended are hereby declared to be civil service positions. Is that provision in the record? That part of the Charter in the record?
Honestly, Your Honor, I'd have to go back and check. I don't have that here with me today in front of me.
That's 4-306 of the city code.
If it is not,
I mean, it seems like to me that would be, your code tells you where to find the civil service positions in that part of the charter. It seemed like to me the court or the parties would want to bring that to the court's attention.
well, if it is not in the record per se, it's a public record, assuming the section that you are looking at is still valid and still in place, and I would think that that is something that the court could take judicial notice of, and if the court desires or requests supplemental briefing, that's something that could certainly be done. If I can, in the remaining time that I have, I'd like to move to the issue of the order that was entered in this case. I want to try to be as professionally polite and respectful as I can, but I have to say on behalf of the city, the order that we have that got entered after this hearing, I think is lacking in some areas.
I mean, is this any different in a situation? Courts often ask if it's going to be a bench trial for a pretrial brief.
Sure.
both parties submit a pretrial brief. They may even say, give me proposed findings of fact and conclusions of law, and then they will borrow. I mean, I've certainly had situations in my past where they've taken it all and said, that's the ruling of the court. That
Right.
matched up with what was proved. How is this circumstance any different when they did it? I mean, the court certainly didn't telegraph its decision, but it had to exercise some level of independent judgment to determine which of the two certainly contrasting proposed findings of fact conclusion law were the ones that the court felt was appropriate.
I understand what you're saying, Judge, and I've had the same experiences. Way back when we were doing workers' compensation trials in courts, that was typically the practice. And some of the things that I would point out here is that this order, respectfully, I think lacks a lot. There is a lot of information that came from this hearing that is not referenced and is not cited to. There are no citations to the record in this order. The proposed order that we had included citations to every one of the 60 facts that we proposed was backed up by a citation. This order, and getting to your question and point about it being a product of the court's independent judgment, again, respectfully, I don't know what was going on with Judge Allen at the time, other than the fact that he was in the process of trying to wrap up his time on the bench. And literally what happened here is he took the petitioner's order and signed it and did nothing with the order that the city submitted. I reasonably anticipated and thought, based upon the comments at the end of this trial, when he told us, council, submit your orders in a Word format, that what would happen is exactly what you're suggesting. It would be a cut and paste, kind of a mixing of something from Mr. Cobb and something from the city.
Counsel, the record doesn't, and maybe I missed it, but it doesn't seem to contain a filed version of the proposed findings and fact by the parties. Were those directly submitted to the judge? They weren't
those
submitted through
were.
the clerk's office? Okay.
Your Honor, they were, and also, for the record, we got into a little bit of a mix-up with the clerk in Murray County about what had been previously filed regarding exhibits that were attached to a motion for summary judgment, and then there were a couple of post-hearing, post-trial motions related to the record. I reasonably assumed, and I think that our proposed order and the proposed order that got sent by the petitioner were part of the record. They certainly should have been, because they were sent to the judge, and he said that he would take a look at both and consider them both. So that's what I'm basing this on. As it relates to the order, though, perhaps the most important thing that I want to point out, there is a witness that I called by the name of Mac Reagan. Mr. Reagan is currently the Director of Public Recs. Yes, sir. Mr. Reagan testified, unimpeached and uncontradicted, that he had had at least one interaction with Mr. Cobb in which Mr. Cobb acknowledged and said to him, admitted to him, that he understood that now being a department head as the fire chief, he was not entitled to this protected status, i.e. he was not entitled to the hearing that he now seeks. That is an admission under 803 1.2, and I purposely called Mr. Mack as the last witness to see if petitioner would then get back up with rebuttal proof to contradict what Mr. Reagan had to say, and they elected not to do that.
Okay, so I want to make sure I'm clear on your position, though. You're not saying that the process that the court followed here, asking for two separate proposed findings of fact and conclusions of law to be submitted in chambers for the court to use for its final, is problematic. What you are challenging is, as I see it, is one, that the findings aren't supported by the record citations, and secondly, it includes none of the findings that you proposed that you think were undisputed.
Yes.
Okay.
Yeah. In particular, the testimony related, the uncontradicted proof of Mr. Reagan, who isn't even mentioned as a witness who showed up at trial. So, thank you.
Thank you. Good morning, and may it please the court. Brandon Watt of the Murray County Bar, here on behalf of the appellee, Mr. Cobb. In February of 1999, Mr. Cobb was hired on as a probationary firefighter. A year later, in February of 2000, Mr. Cobb was hired full-time as a firefighter for the City of Columbia, and at that time, he was granted civil service status. For the next 24 years, he served the City of Columbia in various capacities, and ultimately in 2017, he worked his way up to the fire chief of the City of Columbia. We moved forward to March of 2024, when the city notified him that his employment was going to be terminated. Essentially immediately, he sent written requests to have his civil service hearing, and both the city manager as well as the civil service commissioner, written requests were sent to both of those individuals. And in particular, the city manager, Mr. Massey, replied back and responded that because he was allegedly a department head, that he was not entitled to a civil service hearing. Because of that information, the next month, through trial counsel, he filed his petition for a writ of mandamus with the Murray County Circuit Court. The first issue before the court is, number one, is he entitled to a civil service hearing? Your Honor already mentioned it's a fairly simple issue. And the analysis should begin and it should end with the charter and with the municipal code. I would say that the analysis begins and ends with section 1-201, subpart 2, specifically subpart E of subpart 2, where it specifically says, and in my brief, I bolded it, that relative to the chief of the police department and the chief of the fire department, the director of the public safety does not have the ability to suspend either one of those individuals without first seeking the concurrence of the city manager. And if they're going to allege that either one of the individuals, the fire chief or the police chief, have committed something more than a minor infraction.
And so in this case, where Mr. Massey was determined to be both the city manager and the director of public safety, he would confer with himself?
Well, I think because there was no director of public safety, I think it was Your Honor who mentioned.
Well, I thought the court found there was a director of public safety, and it was Mr. Massey.
Well, I think that he would be, and he would be the de facto public.
So what evidence supported that finding? Did Mr. Massey testify, I'm also the director of public safety? Is he getting extra pay than the city manager? I mean, what facts support that finding?
I think it reverts back to the provision in the city charter, specifically Article 6, Section 6.01, which, and I think it was Judge Usman who quoted it, where the city manager would essentially have control over all departments, offices, and agencies appointed by the city manager. The city manager would all of those departments, offices, and agencies would be under the city manager's direction and supervision. And the city manager has the express authority to either appoint someone to serve in that particular role, or he can serve in it himself.
And he exercised that express authority?
I think he had to have done it because he chose not to appoint someone as the director of public safety.
So any unfilled position is held by the city manager?
Not necessarily, but I think in this particular instance, if the city manager, who is directed by the municipal code over and over again via use of the word shall, that a director of public safety shall be appointed, if he's not going to comply with the direction of the municipal code that says shall,
he is de jure the director.
I think he has to be. Okay. If he's going to violate the terms of it and not do what shall means.
Did the court make a conclusion of law to that effect? I think the answer is no.
I agree with that. I mean, I don't know that the court explicitly said that he would have been the de facto director of public safety. But when you go deeper into that rabbit hole, the logic of it really crumbles. And it crumbles because of the structure of the way that the city structured its municipal code. When you look at section 1-201, it talks about there being a Department of Public Safety. There is supposed to be a director of the Department of Public Safety. Obviously, there's not one that has been formally appointed.
Is there there's no separate fire department? It is under,
It is within the Department of Public Safety.
then why did Mr. Cobb be requested to go to department head meetings and other things like that?
Well, I think
Didn't he have hiring authority or anything like that too?
I do believe that he had hiring authority within the
Well, that
the
sounds
fire
kind of like a department head, doesn't it?
I disagree, though, because of the way that the municipal code defines the Department of Public Safety. When you look at the way that the code is structured, there are two entities within that department. If he's going to be the department head over the Department of Public Safety, by the way that the city's own municipal code is structured, he is not only the head of the fire department, but he's also necessarily, because of the way that it is structured, he would also be the head of the police department.
So, do we know who all showed up at the department head meeting? Does the proof show that?
I don't know that it spelled that out that
Okay.
in depth.
I mean, like, for example, did Mr. Massey attend?
I'm sure that he did.
Okay, so why would he attend as department head for public safety and your client be there as well?
Well, I would
Because
assume.
he's the department head.
Well,
Was the police chief there?
I don't know that the record goes into it that in depth. I think that you could have multiple individuals, maybe even the assistant fire chief or the assistant police chief, who are attending these meetings and they're addressing various matters of concern of the day. But that doesn't, by his attendance, that doesn't necessarily trump the express provision of the municipal code where it says there's a Department of Public Safety, and within that is the fire department and the police department.
What, I asked a question earlier about the Civil Service Board code provisions. Do you know anything about Article 6 of the charter dealing with the name civil service positions?
Your Honor asked a question about whether that was in the record. I looked at it on my phone just before I got up here. It appears that the charter is in the record as Exhibit 1.
But is that particular citation in there? That was what I'm worried about.
The 6,
Yeah, if you look at 4-306, positions covered by civil service, which would seem to answer the question here, it references all positions defined in Article 6, Section 19 of the Charter as amended are hereby declared to be civil service positions. Do we have that?
Article 6, and then Section,
19 of the Charter?
I'm not seeing a Section 19 within Article
6.
6.
So that may be an old charter.
It could be. The version of the charter that is Exhibit 1 was dated maybe 2013. There's a footnote referencing a private act from 2013.
So there's maybe a bad cross-reference in the city code.
There could be.
Do we know if there's an equivalent provision in the current charter, other than what you've already cited under 121, to Article 6, Section 19?
Not of which I'm aware.
Okay.
Counsel, with regard to the Lakeside issue, do you agree that the order in this case is a verbatim, essentially reflection of the proposed order that you submitted?
I do.
So, given that, and how is this not violative of Lakeside? And isn't Lakeside designed to protect against a judge getting two proposed orders and saying, I'll take that one? And isn't that the point of Lakeside, or at least a major point of Lakeside?
Well, I don't believe that it is violative of that case, because when you look at another case that I cited, which is the commercial painting case from 2024, that court was referencing that it's obviously preferable that the court would receive the differing orders from however many parties there are to the case, and you might make an edit or two here or there.
Are there significant differences, though, between the circumstances here in commercial painting? And in commercial painting, there was a subsequent motion where the trial judge confirmed, yep, this was exactly what I was thinking. These are my exact thoughts. And also there was no, I mean, essentially it was a harmless error determination in commercial painting there, with the idea that there was also no substantive argument in opposition to the ultimate ruling the court had reached. Here there's clearly a substantive objection to the trial court's ruling, and this seems rather different than the circumstances of commercial painting.
Well, you mentioned that there was a motion and then the trial court affirmed that what he or she had ordered was in fact what was intended to be ordered. And I think that the difference here is that the city had the opportunity to file a Rule 52 motion.
Are you required to do that under Lakeside, though?
I don't know that you are required to, but some of the cases that I stumbled across, including Delavan, Delta Corp., I believe that case referenced that if the defendant had been dissatisfied with the order submitted by entered by the trial court as submitted by counsel for the plaintiff, Rule 52 provided the defendant with an opportunity to file that motion to alter or amend.
I understand you're saying that this doesn't violate Lakeside. Let's assume for a moment that it does. Is this an appropriate case if it's a violation of Lakeside for the court to soldier on, or is this a case that would need to go back if there's a Lakeside violation?
I think it is. Number one, during the trial, there was a motion for a directed verdict at the close of the proof. The court denied that and concluded that there was a prima facie case of establishing the necessary elements for a petition for the writ of mandamus to be granted. The court was given a Word document. Obviously, the court had all the opportunity in the world to edit either Mr. Cobb's order or the city's order if it so chose. It obviously chose not to. The transcript from the trial was ordered, and from what I understand was provided to the trial court for its review if it wanted to reference back to the transcript.
But the judge here almost telegraphed the problem we're having today, right? In the colloquy at the beginning, before he was making his crest, he says, "This is going to sound bad."
It's not preferable. I agree with that it is certainly not preferable that this is the way that it was done. But the final thing that I would say, you mentioned the word binary. It's either he is or he isn't entitled to a civil service hearing. And at the end of the day, it's that simple. In my opinion, when we go back to the first issue, he either is a department head or he is not. Because if he is a department...
And that's a fact question, right?
I disagree.
That's not a fact question?
I disagree. It's not a fact question. Okay. It is a question that, I guess it could be a mixed question to some degree, but it...
So we would review it de novo then?
Well...
Aren't you... I mean,
I
I want to make your case for you, but don't you really want us to take this as a fact issue? Because it comes to us with a presumption of correctness.
Well, and when you just look at it, though, when you look at the facts, if we're looking at the code and we're looking at his position as the fire chief, the code says the department head of the department in which the fire department is a member. There are two departments within the bigger department, the fire department and the police department. There is absolutely no dispute in this record that he wasn't the police chief. If he's the department head over the Department of Public Safety, which is where his department, his fire department or whatever fell under, then he necessarily had the authority over the police department. And there is no proof in this record anywhere that he ever did anything whatsoever relative to the police department. He had zero authority over the police department. And if we're going to buy the city's argument that he's somehow a department head, you have to ignore the structure of how the code set up the Department of Public Safety. You have to completely ignore it because of the fact that he had zero authority over the police department. And because of that, when we turn to it,
So what do we do when the actions of the city don't match the actions of the code?
Well, I think the simple solution is we have to defer to what the code says. The city makes a lot in its brief about the idea that there's pre-prepared forms, there's organizational charts, there's websites, he's attending department head meetings. That doesn't trump the code. We're bound by what the code says.
So even if that code provision regarding the Department of Public Safety has never been implemented, we're supposed to go along with something that's never been implemented and ignore what's really done. Is that what you're telling me?
Well, I disagree with the way that it's couched. because of the fact that when you turn back to the, Article 6, Section 6.01 of the Charter, which we've discussed already, it was the obligation of the city manager to appoint a director of public safety. That apparently has been violated since 1968 every single year. If the city is going to violate its own code in declining or otherwise refusing to appoint a director of public safety, that doesn't then turn on violating Mr. Cobb's right to his civil service hearing by essentially making him the de facto director of public safety, given that he had no control or authority over the police department, and overriding Section 6.01 of the Charter, which says that the city manager, him or herself, may serve in the capacity alternative to appointing someone to serve in the capacity.
Was there any evidence that the city manager actually served in that capacity?
Well, I think he did by default, because when you
by
look-
firing.
by firing him, because when you
Okay.
look at Section 1-201 of the municipal code, it talks about if you're going to discipline the fire chief or the police chief, there's supposed to be a director of public safety who initially does that, but he or she, if there is a director, they have to have the concurrence of the city manager. So if that position is not filled, then it would just default to the city manager, as opposed to making the fire chief the department head.
Okay.
For those reasons, I'd ask the court to affirm the judgment of the trial court.
Thank you.
Thank you.
I want to make a couple of points to address the court's questions and some of the things that Mr. White brought up. For the record, I assume you know this, but Mr. White did not try this case. He wasn't at the trial. So, all due respect, I think I'm a little bit more familiar with the record and what happened than what he is. That being said, there is no Department of Public Safety. There never was. And the fact that there is still on the books a code section that says that does not mean that automatically, ipso facto, that there is such a department, and it comes into play here. The city, there was testimony through Mr. Massey at trial that clearly established that in order for that department to now legally be a functioning department arm of the city council would have had to have passed a compensation and classification ordinance. That was never done. There's no record, there's no proof in the record that it was ever done. And the idea that Mr. Massey or the city had some obligation to act on or to enforce, and that
Council, doesn't the city have an obligation to adhere to its charter? And that is the local constitution here. And
Your
Tennessee
Honor-
Supreme Court's been very clear that actions inconsistent with the charter are void or voidable. And isn't there an obligation here for the city to adhere to its charter?
Well, simply because they decided to pass this or create this code section. It's not an ordinance, but it's the code section, 201 that we're talking about, back in 1968, but subsequent councils never either took it upon themselves or decided that they didn't want to fund it, that wasn't something that they needed at that point in time. I don't think suggests that they have violated their own charter. I mean, respectfully, it's a bit ludicrous to suggest that Mr. Massey should have gone out and hired a director of public safety when he had no money to do it. There was no budget to do that. He could have run an ad and said, yeah, come on, be my director of public safety for the city of Columbia.
So that department isn't even in the budget?
No, sir. There's no proof that that ever took place. He could have run all the ads that he wanted to, but if someone had shown up, he would have said, well, arguably, the city might have the authority to hire you, but we have no money to pay you, there's no department, and there's no infrastructure to support it.
What created, I'll use that in air quotes, the Department of Public Safety?
It was an act that was undertaken by the city council in 1968
Okay.
to amend the city code.
So it was never in the charter?
No, sir. As I understand it, it was added to the code. There are other sections of the code, frankly, if you look at, ironically, if you look at Chapter 2, Section 6201 and 6202, It talks about a city jail or county workhouse may be used. And it references the Director of Public Works and the Director of Public Safety. There no longer is a city jail in Columbia. Now, is that in the record? No. But I can represent with 100% accuracy and certainty that's not part of the city operation. Is this perfect? No. But does it rise to the level that it was arbitrary and capricious, and that's the standard that you need to focus on? I suggest not. My familiarity or my experience with extraordinary writs has been more with writs of certiorari. Standards are the same, and to me, the question always seems to be, was there at least an arguable reason and basis to justify that the decision was made the way it was? And here there is.
But isn't the determination of whether the fire chief is a department head at its heart a factual question?
I would submit it is, and
Okay.
I think we proved that he was a department head. He admitted that through the conversation.
You would say the evidence preponderates against that finding?
Absolutely, absolutely. So, if you have no more questions, I'm done. Thank you.
Thank you very much.
Yes, sir.
Thanks. Thank you both. And would you call the next case, please?